Hey, all persons having anything to do before the office of justice of the appeals court now sitting in Boston, far within the Commonwealth. JOANNE, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today on the panel are Justices Desmond and Wood. Will be the panel for all of 5 cases today. We've read everything in the briefs, and my best advice is to get right to the point in your argument. With that, I'll call the first case, 25P 117 Commonwealth versus Cheatham. Mr. Benyon.
To the presiding justice, and may it please the court. 2 issues here today. Number 1, the judge erred in denying the defense request for a lesser included instruction on indecent assault and battery. And 2 is a sufficiency argument. I'll start with the instruction first. So in this case, if you'll look, the issue here is whether there is a rational basis to acquit the defendant on the greater charge of rape and convict on the lesser included. Here, there was. If you look at the testimony, it's in my brief on page 35, it's not conclusive of penetration, and that's the issue and the problem here. The jury could have found that a simple indecent assault and battery took place and not penetration. If you look at the testimony in volume 2, this is around page 62 through 69 and 70. Her testimony does not say anything close to a definitive answer as to rape. Defense counsel's motion was reasonable, and the judge should have granted it. As I look at this record, there's simply no issue there's no issue as to penetration occurred, and that's, again, the issue.
The victim testified that on August 23rd, the defendant took her to the fire escape, held her there, and put his penis in her vagina.
I'm sorry, can you say that again?
He put his penis in her vagina. That's penetration.
Yes, but we're talking about what occurred for count 3. That's
count 3, yeah.
Yeah, outside of the
She didn't equivocate at all about penetration.
Again, if you look at the transcript, he pulled her bottoms down. She alleged that he took her towards the fire escape, that he held her there, and then he put her down towards his hips.
And then?
Again.
And then he put his penis in her vagina.
Yes, but the difficulty here is that even if the issue is that the statement was sufficient, that's still a credibility determination. The jury acquitted on the first 2 rapes, and
the third rape had corroboration, right?
Are you talking about the DNA evidence?
There's DNA, and there's the photographs of the bruises she got from the fire escape.
So bruises on the fire escape on the knees are not going to indicate penetration.
No, but they corroborated how he raped her.
Well, corroborative, yes. As for DNA, the issue here is that semen is not static, and it can move or drip, and that's the issue here. If you look at
the DNA wasn't conclusive, but it was male DNA, and the defendant fell within the 14% of the population that could not have been excluded.
Right. But again, the DNA is exterior. There's nothing that puts the DNA inside the vagina, and that's one of the issues that I want to...
It was a vaginal swab.
That's true. So if you look at the appendix on page 69, there are a bunch of photographs of the test kits. And you can see that some of the some of the kits are labeled pubic hair combings, underpants, additional swabs, those are the knees and the hips. With respect to the vaginal swab, it says vaginal swab and smear, and smears. Also perianal swabs, and it was the perianal and vaginal that were found to have DNA that could be tested. But nowhere here does it say that this was a smear swab. It's the smear swab that is the interior, vaginal is exterior. And so again, what we're looking at is evidence of exterior DNA, while corroborative. There's just not enough here to say that the judge was correct in not instructing on indecent assault and battery.
Can you just, see, I think you just said smears indicate taking a sample from the exterior of the vagina. That's what you just said? I just want to make sure I got that right.
Yes.
Yeah, and record site, I know that I got you. RA 69 shows that these were swabs and smears. Yeah. What's the record support for the fact that a smear is external? Is there record support for that specifically?
No, it was. I'm using the definitions and
Okay.
experience doing these types of cases and testimony. I'm fairly familiar with the fact that a vaginal swab is exterior, a smear is internal. And while
Sorry, I think is it the other way around, or so a swab? You just said swab is exterior, smear is internal.
I'm sorry, they're both swabs. The smear is interior.
Okay. Okay.
Was that argument put before the jury?
No, I don't believe so. Like I said, there wasn't a lot of discussion as to this point. The question is, the judge may not have been aware of that distinction, and that might have been why he thought that there was more than sufficient evidence for penetration, where I don't think there is. Again, the issue here in the test is whether it was reasonable for defense counsel to make the objection where the jury could have acquitted on rape and found guilt on indecent assault and battery. The issue here is penetration. There isn't proof that there was penetration. Well,
that wasn't the defense at trial.
I'm sorry?
There was not a defense of indecent assault and battery.
The defense was that it was
That she can't be believed.
that she can't be believed.
Right. Not that he only indecently touched her.
I understand that, but defense counsel, after looking at all the evidence, made the request, and he understood that this jury could have acquitted on rape on count 3 and found guilty on assault and battery. The problem is we don't want to give the jury an all or nothing idea of the defense.
Do you think that would have been a compromised verdict?
A compromised verdict in the sense
To not find him guilty of the rape and to convict him on an indecent A and B?
No, that's up to the jury. Again, the issue here is whether it was reasonable for counsel to look at the evidence and the judge and find that the jury could have equivocated on rape and could have found on indecent assault and battery. According to her testimony, it could have been indecent assault and battery. It could have been rape. That's for the jury to decide. But there was certainly not enough here to say that penetration took place, taking that issue out of the defense.
So I want to circle back to Justice Meade's question. The argument was that he didn't do this at all, she's lying. Do you have a case that establishes that the lesser included instruction is required regardless of whether the defense raises that lesser included as a defense? Understand the question?
I think I understand the question. So in my brief, I talk about the importance that courts have prescribed on when the defendant asks for a lesser included. Now, I understand that
he clearly asked for the instruction.
Yeah, he did.
Right. The question is, if he doesn't actually make the argument to the jury, he makes a different argument to the jury, is that relevant to whether he's entitled to the instruction?
no, I don't think so. The test is pretty simple, and again, the test is outlined.
Right.
There has to be some evidence that differentiates the lesser from the greater offense. And that's exactly what the judge said to defense counsel. And he asked for what that evidence was, and he cited Donlan, and there was none. No evidence that differentiated the greater from the lesser.
Here, the issue is indecent assault and battery is a lesser included of rape. The issue is penetration. Even though the defense stuck to its guns and said that this victim couldn't be believed, which is what the jury thought on counts 1 and 2, the difficulty here is because the jury had heard so much testimony, and before the verdict, you don't know what the jury is going to believe. And so defense counsel wanted to hedge his bets and just make sure that with respect to this count, again, the testimony of the victim is going to be...
We're not faulting him for asking, but there has to be a legal basis for it. There has to be a factual basis for it.
In this case, there is. There's no evidence. The evidence is not concrete that penetration took place. That's for the jury to decide. And that's what defense counsel was
His cross-examination all went to her credibility, not to whether or not she was penetrated. And the closing argument is the same.
But it's up to the jury to determine how they view the evidence as it comes in. Again, defense counsel can make their claim of a defense, and in this case, the defense was that the victim shouldn't be believed. Again, that worked for counts 1 and 2. But when they go to the instruction phase, defense counsel it's entirely appropriate for him to look at this and say a lesser included would be beneficial because the jury could find, again, that's a test, that to acquit him of the rape and find him guilty of indecent assault and battery. As I look at this case, all that occurred was the judge sent this to the jury on an all or nothing defense. But the defense didn't want that. They specifically asked for an instruction. And on this evidence, it seems pretty clear that the jury could have found him guilty of indecent assault and battery and acquitted him of the rape, like they had the previous two. And with respect to what she said at I would argue, as I read the transcript, her testimony as to the third rape, again, is up to the jury to determine. I don't look at it as concrete evidence. Again, credibility issues make a determination, and that's why it's so important to give that to the jury. Defense counsel was entirely appropriate for making this claim. I think the judge was wrong in this case. If you look at the evidence and you look at the test for a lesser included, I think you're going to find that it should have been given in this case because the jury really could have come back with an acquittal on rape. And that's the issue here. Any other questions on that first issue? The second issue is a sufficiency argument. Again, not enough evidence to show penetration. Hopefully this argument highlights the deficiencies in the case in the first argument, from the first argument. If there are no questions on sufficiency, then I will rest.
She testified that he penetrated her vagina. Why isn't that sufficient?
Where believed. But again, the issue of credibility is one that's for the jury. In this case, we're talking about penetration. I kind of go back to my first argument with respect to the fact that at the charging station before the jury went out, nobody could know how the jury was going to view the evidence. They didn't know.
That's not part of our review, though.
No, it's not. But not sufficiency. I'm actually just jumping back to the first one.
I thought we were done with the first one.
I am. I'm using the sufficiency to highlight the problem on that first issue.
At one point, she testifies that the penis went nowhere else but her vagina.
I'm sorry?
At one point, she testifies that the penis went nowhere else but her vagina. Is that accurate? Yes.
But again, it's up to the jury to make that determination of credibility. I understand that they acquitted him of the first two charges, but again, this...
which suggests that they were paying attention to the evidence.
It does. But the issue here is these kind of cases, especially with this victim, can raise passions in lay jurors. And the problem here is we want to make sure that the jury acquitted of proof beyond a reasonable doubt then something lesser, like out of an overabundance of caution. Having found the defendant guilty, or having acquitted the defendant of the first 2 charges, it kind of ups the pressure for the jury if they think something occurred to convict him of something. And that's the problem here is...
You expressly declined to make the inconsistent verdict argument in your brief.
I did.
Are you revisiting that?
No. Are there any other questions?
Seeing none, thank you.
Thank you.
Ms. Palumbo.
Good morning. May it please the Court, Karen Palumbo on behalf of the Commonwealth. With regard to the lesser included offense instruction, the evidence of penetration here, as the Court has already noted, was unequivocal and unchallenged by the defendant.
Yeah, I don't actually entirely agree with that. So I'm looking at the defense lawyer's closing argument, page 14 of volume 4. And I see that there's obviously, so he gets into this business of the number of skin cells. He does some math, and he says there are 6.9 cells, and they don't have to be, and they're not sperm cells. They are, therefore, I think it's clear, skin cells. I may be wrong about that, but I think they're skin cells. But they're not sperm cells. So his point, I guess, is that he's disputing that these cells got there as a result of penetration. He seems to be, and there seems to be no dispute that it's a very small, a really, really small amount of biological material, which seems to probably be his biological material. And so it seems to me that that's at least suggesting that he's disputing penetration. Why is that not true?
I disagree with that, Your Honor. He talked about the few number of cells, and as you said, the evidence, the DNA evidence in this case was not definitive. It was just a piece to the puzzle. His closing and the case at trial focused on the victim's credibility. He focused on the messages that she sent to the defendant, that she loved him, and she asked him to come over.
So do you have I'll ask you the same question I asked your opponent. Do you have a case that establishes that, let's just assume for the sake of argument that what I just read isn't challenging penetration, and isn't raising something happened but less than penetration. Let's assume that he's just limited to credibility. Is that dispositive to whether he's entitled to a lesser included?
It's not dispositive, but we do have a case. This is Commonwealth. There's a couple in my brief cited, but this one is Commonwealth v. Martinez, and Justice Meade was on the panel. And
great, thank you. What's you said another one?
I'm sorry.
What you said you had 2. Maybe.
It's this is sorry, 103 Mass Appeals Court at 1108. This is an unpublished, but there are other. But I just brought this, given that Justice Meade was on the panel, and
I've been on a lot of panels.
but well, relative to this case, the only evidence supporting the penetration element was the victim's testimony, which was not challenged on cross-examination in a manner that put penetration sufficiently in dispute. If the jury credited the victim's testimony in this case, as well as in this case, the evidence would support only a conviction of rape and not of the lesser included offense of indecent assault and battery. And I would suggest that the evidence here, there's no view of the evidence to support indecent assault and battery. And with respect to the minimal semen, penetration does not require that the defendant ejaculate in the victim. So that argument, it misses the mark, quite frankly.
No, well, I mean, I want to spend a second on that. I understand, I read the cases, and I acknowledge and I agree with the case law that there doesn't literally have to be penetration to establish the elements of rape. There can be something in the neighborhood. The penis touching the exterior portions of the vagina, I think will be I think. That's the point. I get that. What I'm wondering, what I'm struggling a little bit more with is whether the defense has to literally say that, and or where, at least on the facts of this case, there's very, very small amount of biological material, and the defense lawyer at least points that out. If that is sufficient to raise a question about penetration, accepting the definition.
No, I don't believe so, Your Honor.
Okay.
In addition, the victim's testimony alone that the defendant penetrated her, this court and the SJC have held, is sufficient to withstand a motion for required finding as well as conviction beyond a reasonable doubt.
I agree with that. I'm not asking, I think that's the sufficiency argument. And I agree that credibility is for the jury.
Yeah.
And I agree that she clearly said, you know, he penetrated me. So that's sufficient evidence
Yes.
for a conviction of rape. What I'm asking is I'm focused on the first argument, and where the defense lawyer points out the very, very small amount of biological material. Is that sufficient under the case law to warrant the lesser included?
No, I don't believe it is, Your Honor.
Okay.
I think the case law is pretty clear. There has to be some evidence to support that claim. The judge cannot give the jury an instruction to convict the defendant on a crime for which they can't convict him. And in this case...
If there was no evidence that put the element of penetration in dispute, and defense counsel nonetheless argues in his or her closing that there was no penetration, would that justify?
No, I don't
lesser
believe so. I
included?
think the judge would be well within his discretion to deny that request where the evidence just simply didn't support that assertion, and it does not support that assertion in this particular case. So I would say that failure to give this instruction to which the defendant was not entitled in this matter did not prejudice the defendant. I know you've already addressed sufficiency, but I would, again, the court noted that the first two rapes were uncorroborated. Not that that is a reason to acquit, because the victim's testimony alone is sufficient. But in this case, the jury had a lot more. They had the physical evidence. They had the photographs of the bruises and abrasions on the victim's knees, the bruise on her right inner thigh, and there was also redness in her genitalia area, all corroborating the victim's account. The DNA evidence was not definitive, as the court already noted, but the defendant was part of the 14% that could not be excluded from that DNA evidence.
There wasn't a sane examination in the first rape, right?
No, she didn't report the first rape. She didn't report that until this rape occurred. So those are also factors I'm sure the jury considered when discerning the evidence and reaching their verdict. So if the court has no further questions, I would rest on my brief and ask that the
Thank you.
court affirm the defendant's conviction.
Thank you both.
Thank you.
Thank you.
Our next case is 24P952, Commonwealth versus BARAN-GARCIA. Ms. Taylor.
Good morning, Your Honors. May it please the Court, Hannah Taylor on behalf of Mr. BARAN-GARCIA. I'd like to start with the claim that there was insufficient evidence of his identity as the perpetrator of the assault against the second victim, TK, where the evidence pointed to two possible suspects, and then time permitting, would like to address the errors relating to the other victim, JJ's identification of Mr. BARAN-GARCIA as to the attack on her. But even if it was fairly proven that BARAN-GARCIA was the person who committed the assault on JJ, and I maintain that it was not, for reasons that I hope to get to, there were so many differences between the perpetrators of the two offenses that even in the light most favorable to the Commonwealth, which I understand is a very high burden, no reasonable juror could have found that BARAN-GARCIA was the one who committed the assault against TK beyond a reasonable doubt.
What do you think the most glaring difference is?
I'm sorry?
What do you think the most glaring difference is?
So first looking at the clothing, JJ's perpetrator was wearing a hoodie he pulled up to reveal a knife. TK's perpetrator opened up a jacket to reveal the knife.
So you think that's the most glaring inconsistency?
Well, I think there are a number of ones that all together are pretty glaring. So that was just the first one. Also, TK's perpetrator was wearing a black mask. There's no mention of a mask for JJ's perpetrator. When BARAN-GARCIA was arrested, he was wearing dark-colored sneakers, whereas there was testimony that TK's perpetrator was wearing boots, like work boots. There was also testimony that TK's perpetrator had quite a few items with him, a number of reusable shopping bags, a neon backpack. a bag with white sneakers, and there's no mention of JJ's perpetrator having anything, even though she observed where he was sitting, who he was sitting with, that he was talking to people, that he was going back and forth. The only thing she mentioned that he had with him other than the knife was a rose, nothing about a ton of things kind of crowded around him. Additionally, there's discrepancies in the descriptions of the knives. So JJ's perpetrator used what she described as a huge machete-like blade that was so long she could not even see the handle when he pulled up his hoodie. TK's described her perpetrator's knife as being a chef's knife that was really big or giant. The other witness to that offense described it as cartoonish in proportion. Meanwhile, the knife...
TK identified the knife as the one that was used, right?
I'm sorry?
TK identified the knife that was used in her assault.
Yes, but we don't know whether that was, the knife that she identified was the knife that was recovered from Mr. Baran-GARCIA, and the evidence about the knife that was recovered from him, given by the officer who assisted with the detention, was that it was only 4 to 6 inches long, and so,
Didn't Officer Herrera, if that's how you say his name, said that the defendant was arrested with the knife at the scene?
Yes, a knife that was 4 to 6 inches long. And so, a piece of paper is 8.5 inches, so 4 inches would be half of this. So that's not a huge machete-like blade or a giant chef's knife. Additionally...
Didn't you, even in your brief, you say that TK and a second eyewitness, right? They testified that they saw a man in custody at the Kendall MIT station and that the man was the perpetrator of the offense against TK.
Yes, and...
Why isn't that an ID?
The problem with that is that police took 2 gentlemen who they described as matching the description of the perpetrator, who both had knives. They took Baran-GARCIA off of the train, and actually the other man, William Oriana, they apprehended while he was trying to discard his knife in the trash.
This is a sufficiency claim, right?
Yes.
So we have to view the evidence in the light most favorable to the Commonwealth.
That is true, and there is case law saying that when evidence points to equally to 2 inconsistent propositions here, either that Baran-GARCIA perpetrated the offense or that William Oriana did, that as a matter of law is insufficient. And there is also a case...
There are quite a few similarities, though. I know there's some differences, but there's some similarities in the 2 assaults, right?
Primarily the temporal similarity and the fact that...
A couple stops away, the knife.
3 people?
I'm sorry?
3 people?
Yes, so there were 3 people. The problem is that neither of these offenses were charged as joint venture. I think it is probably...
I'm sorry, they were what?
Neither offense was charged as joint venture. So there may be evidence sufficient to establish beyond a reasonable doubt that one
Doesn't mean the circumstances didn't occur.
Yes, but it means that the Commonwealth had to prove not that just one of the 3 members of the group committed both offenses, which I'm not necessarily prepared to concede, but perhaps there would be sufficient evidence that it was one of the members of the group. But they had to prove that it was Baran-GARCIA as to both offenses.
But in both of them, there's a perpetrator with a knife threatening someone on the train for money, and there's 3 other people with him. And it happens, man and woman, and it happens moments apart, 3 stops away.
TK did not testify that her perpetrator was part of a group of 3 people. That was only JJ, so that's actually another one of the differences between the 2 offenses. Also...
But there was evidence of the older man with the knife that was at TK's assault.
Well, there was evidence that 2 people were apprehended. She didn't see 2 people with knives, I don't believe.
Yeah, on the, right, the pointed question is, on the train car, during the assault of TK, did she testify, or did any other witness who was with her, because there were other people with her, did any of those people testify that they saw with that assailant 1 or 2 other people?
No.
Right, okay.
They did not.
Thank you.
And additionally, the offense against JJ cannot be used to sort of piggyback the identity of the perpetrator of the offense against TK, where they differ in method. I believe there's not a sufficient nexus, despite the fact that, yes, both were on the same train with a knife, in order to allow one to be used as modus operandi evidence of the other, where the methods were so different. One was 10 to 15 minutes, involved an extended sort of ruse with a rose and talk of Jesus, and the other one was just at most 30 seconds and just an immediate demand for money. Second, I'd like to address the Commonwealth's contention that they presented evidence that Baran-GARCIA was arrested with the knife used against TK. That misstates the record. As I mentioned, TK was shown 2 knives at the station. She was told that they had 2 people who matched the description. They both had knives. Here are the 2 knives. Do you know which one was used in the attack against you? And she said she immediately recognized it, and then just described it, saying it was a big chef's knife. But she did not say that she knew which knife was Baran-GARCIA's and which knife was Oriana's. And in fact, when she was asked that question, she said she did not know which suspect had which knife, as did Officer Harrer. So neither witness who testified about the knives knew which knife was with which suspect. And there was no information at trial, no evidence at trial about which specific knife of the 2, because we have no information about the make, model, shape, width, whether the other knife was in fact a huge machete-like blade or a huge chef's knife.
Was one knife considerably larger than the other?
I'm sorry?
Was one knife considerably larger than the
We
other?
have no idea because, again, we have no information about the second knife because although there was testimony that the Commonwealth took both knives into custody and that the officer was sure that there were photographs taken of the knives, the Commonwealth failed to introduce the knives, bring the knives to court and introduce them into evidence at trial, and failed to even introduce any photographs of the knives. So there was no evidence or testimony about saying where TK got on the stand and said again, this is the knife, and then Harrer said, this is the knife that I got from
Right,
DWAYNE.
and it's a little, there was obviously testimony about machetes, that's a word that everybody remembers, that people on the train saw an assailant, I think JJ's assailant, I don't remember, but with a machete. But then there is no evidence that at the T-stop where the 2 fellows are arrested, that anybody recovered anything like a machete at that point. Is that right?
Well, I would say there's certainly no evidence that Baran-GARCIA was found with a machete, and there's actually
Okay.
evidence to the contrary, where the knife was only 4 to 6
Right,
inches long.
right. The
But
other
there's-
knife,
There's
the-
no evidence one way or the other as to the other knife,
Right.
because there was absolutely zero testimony. Officer Harrer, who was the only officer to testify who was at Kendall Station on that day, said he didn't deal with the other suspect, and so he had no information about that knife.
So we know there were 2 knives recovered at the T station, and we know that one of the knives was 4 to 6 inches, therefore not a machete, and we don't know anything about the second knife recovered at the T station.
That is accurate, and,
I thought it was also described as a large kitchen knife.
I'm sorry?
I thought it was also described as a large kitchen knife.
I don't believe so. I believe Officer Harrer testified that
Sorry,
TK
giant
cer-
kitchen knife.
TK certainly did not provide a description of the second knife, and I believe Officer Harrer as well
The
said
first knife. You said there was no evidence describing the first knife, and I
Oriana's
thought I
knife.
read something differently.
No, Officer Harrer testified at page 183 that he didn't know anything about the make, model, width, size, shape of knife recovered from Oriana. And when TK testified about identifying one of the 2 knives, she didn't provide any description of the knife she did not identify. And that's at trial transcript like 137 to 142. Finally, as to insufficiency, there's no evidence that TK, contrary to the Commonwealth's assertion, that TK identified Baran-GARCIA as the perpetrator. So first, she actually failed to make an identification when she was presented with an array prior to trial. JJ did make an identification, but TK did not. The other witness testified that he didn't make an ID of anybody as the perpetrator prior to trial.
Doesn't TK say that the police had the man who had threatened her on the ground?
Yes, and the problem is,
And
again,
doesn't the arresting officer say the man that I had on the ground was the defendant?
no, so I actually looked back through the testimony, and Harrer never testified to having Baran-GARCIA on the ground. And as I said, 2 people matching the descriptions were taken into custody at the same time and place. And in fact, I would argue that actually there's consciousness of guilt evidence to that detention as to Oriana, but not as to Baran-GARCIA,
Well,
where Oriana was,
I'm sorry, when you say 2 people matching the description, wasn't one younger and one older?
as to JJ, there was no, so TK did not describe the age of her assailant at all. So we do know that, according to JJ, that her assailant was in his 20s, but TK did not provide any information about the age of her attacker. And so as to the 2 people being taken into custody, when Oriana was taken into custody, he was actually trying to dump his knife into a trash can at the time, which could be consciousness of guilt evidence. Additionally, as I said, they were both taken into custody at that time, and while TK and the other witness testified that he was seen lying on the ground, the perpetrator was seen lying on the ground with police, Harrer, who was the officer who assisted, never testified to having BARAN-GARCIA laid out on the ground. He testified that he assisted in getting BARAN-GARCIA off the train and bringing him over to the platform area, handcuffed him, and then stayed with him. He did not testify in any way to his physical positioning. Additionally, where he testified that he had handcuffed BARAN-GARCIA, I believe not TK, but the other witness testified that he didn't know whether the perpetrator was in handcuffs when he saw him. And so given that there's no description by the detaining officer as to BARAN-GARCIA, that BARAN-GARCIA was on the ground, I would suggest that that actually supports an inference that the person TK and the other witness saw was actually Oriana and not BARAN-GARCIA. And so the only identification was that they saw the perpetrator in custody, but it could have been one of two people, and actually, I would say, more strongly supports an inference that it was the other person and not my client. So because the evidence at trial at least equally supported two inconsistent inferences, one, that BARAN-GARCIA committed the assault on TK, and two, that Oriana did, as a matter of law, that's insufficient evidence, and he's entitled to a not guilty finding.
Were both men at some point on the ground? Both guys with the knives?
There's no information in the transcript suggesting that BARAN-GARCIA was ever put on the ground. So we don't know who was on the ground, but I would, since Officer Harrer testified to what he did with Mr. BARAN-GARCIA, and it did not include putting him on the ground, I would suggest there's at least an inference that it was the other person.
Didn't the arresting officer testify that it was the defendant who was on the ground?
He did not. So that is at, as I said, so that's at transcript 170 to 171, where he talks about, as I said, assisting in taking BARAN-GARCIA off the train, bringing him over to the platform area, handcuffing him, and then staying with him. But there's nothing about whether he was on the ground or not. And he also did not testify that any witness came over and identified BARAN-GARCIA as having attacked TK. If there are no further questions on sufficiency, I realize I only have a minute and a half left, but would like to spend a brief amount of time on the claim about what happened at the motion to suppress hearing. So Mr. BARAN-GARCIA had a right to a fair hearing before an impartial tribunal, and he was denied that right at the motion to suppress hearing, where the judge's conduct created the appearance of partiality. I'm aware that judges are permitted to question witnesses and to interject in proceedings for efficiency, but they're not allowed to do anything if they do it in such a way that even creates the appearance of partisanship. And that's critically important to the functioning of our justice system, because even the appearance of partiality damages the integrity of the judiciary and the judicial process and undermines...
What he's doing is trying to make sure that the relevant information is brought out, why is that let's just say my characterization is fair. Why is that an appearance of partiality?
Because his questions went beyond simply clarifying the evidence and actually brought out evidence on topics that the prosecutor was not inclined to question about. And as well, the way that he asked those questions or interjected, as I said, gave the appearance of partiality, in particular with both of the Commonwealth's witnesses. When the Commonwealth attempted to rest, the judge prevented her from resting. It was unsuccessful.
And you say in your brief that the motion judge elicited substantial information that helped defeat the motion.
Yes.
But you don't identify any of it.
Oh, I'm sorry, I thought I had. It was how the array
Is it the Silver Santiago instructions that the judge wanted to be done?
I'm sorry?
Is it the instructions on how you do the array and the
Not just that.
photo ID?
So he was the one who elicited information about how the array was put together, where the prosecutor tried to kind of skip over that part, as well as the advisements that were given to the witness. But again, it's not about any of one of the specific questions or interjections, but it's about the appearance of partiality. So
All right, we're going to leave it there. Thank you. Your time's up.
Thank you.
Ms. Moores.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth, asking that this court affirm both convictions. I'll start with the sufficiency issue and then move on to the other issues as time allows. So on the sufficiency issue, although the descriptions of the two perpetrators by the two different victims were not identical, there were important characteristics that they both described kind of in a similar manner. The first victim described the perpetrator as having a black hoodie. The second victim described the perpetrator as having a black coat with a hood up.
But also underneath that, a yellow coat, I think?
Yeah. So there were definitely descriptions that didn't match between the two suspects. But the second victim saw the defendant for an incredibly short amount of time because with the second victim, passengers on the train intervened pretty quickly. So the fact that there's not a perfect description from her is not surprising, and so it hardly detracts from the sufficiency analysis. In addition,
The second victim says that as she was leaving, she saw the person who assaulted her on the ground.
yes, Your Honor.
So how do we know that that was BARAN-GARCIA?
So we have a couple of pieces of evidence that tie BARAN-GARCIA to being that person. One is there was another person who also described the man on the ground, just the witness to the incidences, and he described the officer who was with that man on the ground as having a big knife, I believe. But backtracking a little bit, when Officer Sands exited the train car, he was exiting with the defendant, and he had a big knife under his arm.
How do we know the person on the ground was the defendant?
So it's because of that series of inferences. It's because Officer Sands had the big knife and was taking BARAN-GARCIA off the train, and we know that he was taking BARAN-GARCIA, and then the witness saw the man on the ground and the officer with a big, large kitchen knife. And because we were able to match those two descriptions, that creates the inference that BARAN-GARCIA was the man on the ground.
But there was a second man, and there's no dispute that the police took a knife from a second man, right?
That's correct, Your Honor.
And we don't have any description of the second knife, or do we?
We do not have any description of the second knife, but what we do have is testimony from the second victim that it was immediately recognizable which knife belonged to the defendant, suggesting that these knives were not similar in nature.
That's not my recollection of the record. My recollection is there was no doubt that the knife she saw was the knife that was used to assault her. That's what you just said, is there's no doubt that that belonged to the defendant.
Oh, I'm sorry. I misspoke, Your Honor.
Okay.
When she was given the two knives, she
Right.
immediately recognized the knife that was used in the assault.
But
Right.
Did she know that that was the knife that the defendant possessed?
She didn't have any, so there's nothing to tie it to
Put it
the
differently.
defendant from her testimony.
She
if that's what you're
identifies
asking.
a knife as being the one used on the assault.
Yes.
Do we know that that was the knife found in the defendant's possession?
So she did not know where the knife had been recovered from. There's no direct evidence. There's no direct testimony that the knife she identified was the knife recovered from the defendant, but where she immediately recognized which knife was the knife used, suggesting that these knives were, not similar in nature, and where the officer who took the defendant off the train had a large kitchen knife, similar to the way the second victim described the knife that she identified, where he had that type of knife under his arm while he was taking the defendant off the train, that it's a reasonable juror could infer that that was the knife taken from the defendant.
Are you saying, still not quite following you, but I think you maybe are saying that she linked the knife, there's no doubt she saw the knife that was used to assault her. We're all
Yes.
agreeing on that. And I think maybe you're saying she linked that knife somehow to a specific officer who took BARAN-GARCIA. Does the evidence support that?
So it's not that, Your Honor. There was a testifying officer, and then there was the one who took the defendant off the train.
Can we use their names?
Oh, gosh. I
Well,
believe,
never mind. Don't worry.
sorry, it starts
Okay.
with an H, but
Sure.
Officer Sands was the one who took them off the train.
Okay.
And then the officer who testified to the second incident saw Officer Sands take him off the train, and that officer was able to identify BARAN-GARCIA in the courtroom as the person he arrested, and was able to describe the knife that Officer Sands had under his arm. That description of the kitchen knife was very similar to the second victim's description of the kitchen knife that she saw. It is not, this was not directly stated by witnesses in such a clear way, so it does require kind of a few steps to get there, but it is still a reasonable inference that the jury can conclude. But in addition...
Do you think it's reasonable to infer that there was a large knife and then another knife?
You mean two large knives?
No, I mean a large knife. One is clearly described as a large knife.
I think that that's a reasonable inference, Your Honor. That, again, was not directly stated because there is literally no testimony as to the second knife, but because of the testimony about how it was immediately recognizable which knife belonged to the defendant, followed up by the testimony of how large that it's the knife that belonged to the perpetrator, followed up by the testimony about how large that knife was. I think that that's a reasonable inference. In addition, though, the fact, although these assaults weren't identical, they were quite similar in nature in a number of ways, just different because I think in part of how long the perpetrator had to interact with the victim. In both instances, it was a stranger approaching a woman on the Red Line train, kind of on this, one stop ended like 3 stops before the other person got on, with a large knife. And although the exact descriptions of the threatening knife vary, they're pretty similar in nature in terms of it being a large knife. In addition to that, there were 3 people who were, I say, loosely involved in the first incidents, the defendant and 2 additional people. In that first incident, the 2 additional people were described by victim 1 as a woman, and then there was an older man. 3 people were ultimately arrested after the second incident. It was a 38-year-old Hispanic man, the defendant, and a woman. And I think that that further supports the inference that this is the same group of people and that the person who committed the first assault is the same person who committed the second.
Remind me, how old's the defendant?
He's in his late 20s. I'm sorry, I don't remember his exact age, but recognizably younger than the other man who was arrested.
But you to go back to what you just said before Justice Desmond's question, that establishes that the fact that there were 3 of them, and they seem to roughly fit the description of the 3 on that JJ described, that indicates the defendant did this. That last piece, you lose me. That how do we know that the defendant, at least with regard to TK, how do we know, because JJ has ID evidence that we haven't really discussed and seems to make that different. But with regard to TK, how do we know that it was the defendant as opposed to his older companion? Accepting that it's the same 3 people.
Sure, I think it's because of the description of the behavior of the 3 people from the first incident, with there being kind of a clear aggressor and then 2 other people who are just kind of hanging around him. So for all those reasons, we'd ask that you find sufficient evidence as to the second offense. Moving on, I'll move on to Judge Somerville's interjections during the motion to suppress hearing. So Judge Somerville has particular methods. He likes evidence to be presented in the courtroom, and in this case, he was interjecting to ensure that the prosecutor presented the evidence in the same manner that he would prefer the evidence to be presented. This is certainly something that a judge can appropriately do. I would argue that this was critiquing the prosecutor rather than assisting the prosecutor, particularly because, like,
You don't think it was assisting, prosecutor versus Commonwealth. It strikes me that he was, it's fair to say that he was assisting the Commonwealth. He might have been critiquing the prosecutor, but it seems that his approach, whether he intended it or not, gave the appearance to an outside observer that he was assisting the Commonwealth make its case.
So I don't think so, Your Honor, for a couple of reasons. I think first, the big piece of evidence that the defense is concerned about is that Judge Somerville elicited or encouraged the prosecutor to elicit testimony as to, like, have the person read the exact warnings that were given. But 4 pages before, that person had testified that they did, in fact, on page 60 of that motion transcript, that they did in fact give the warnings. And above that, there's testimony as to what the warnings normally are, and those exact warnings had already been admitted into evidence as part of the photo array. So this really was a substance over contents of Judge Somerville would like the contents to be read in open court as opposed to admitted as part of a physical exhibit.
None of it was objected to.
No, and that I think is demonstrative of what was going on here. In addition, just like a judge will routinely, if they are limiting a testimony or limiting questions in some way, explain their ruling with statements like, if you want to admit that, you need to lay foundation for that first. And those kind of guidance is not taking a side or it's not being partial to one side. It's just the judge, I mean, like appropriately explaining what needs to happen in order for a person or a litigant to proceed. And that happens all the time in cases. Beyond that, what we're really, so there's kind of,
Well, in my experience, what happened here doesn't happen all the time in cases. It might happen. I've never read a transcript from Judge Somerville before, so I have a small data set to work with. But I've read a lot of motions to suppress, and I've litigated a lot of them. And this was pretty unusual to me. But that's different than saying it was inappropriate. I'm just pointing out that this isn't what normally happens, in my experience.
Well, I think our experiences might be different.
Yep.
Because I would argue, or I would suggest that trying to get an inexperienced prosecutor to lay the proper foundation to give me the information or to give the judge the information on which they need to make the decision that they're asked to make is not uncommon at all. And that there are often inexperienced prosecutors who may have been in the courtroom. And so in this case, was he trying to elicit information that was tipping the scale one way or the other, or was he just trying to elicit the information so that he was informed enough to make the decision that he was being asked to make?
Your Honor, I think in this case it's clear that he was trying to elicit information that was necessary for him to make the decision that he was compelled to make. And Justice Wood, this was a district court case with, at the time, a relatively new prosecutor. I think that you'll probably find that in those kinds of transcripts, this kind of interjection is far more common than in like the superior court transcripts in front of more experienced prosecutors.
But so let me ask you, I guess I read the transcript actually this morning. I went over this exact pages, 60 to 66, so I know exactly what you're talking about. In page 60, question, and in regard to the instructions, were those instructions given in this case? Answer, yes. And your point is, that's drawing on Exhibit 1. Exhibit 1 is the instructions, and so it seems that this information has been elicited. And so, but then, Judge Somerville seems to think it's important to get the judge. That's not good enough. I want to hear literally exactly what each of these instructions was and why. I think to make sure that there's no ambiguity that he actually read each one of these instructions. That's the only thing I can.
So I would actually say that in my limited experience reviewing Judge Somerville's cases specifically, he prefers that evidence be presented, like walked through in open court with the prosecutor as opposed to submitted as documentary evidence. So that's more of a personal preference of his. Before page 60, or before transcript page 60, you'll see that officer who's talking about the instructions actually talks a little bit more about, are there routine instructions given in every case, were those and then it gets to the question on page 60 of were those instructions given here. So there is more of the kind of build up about this is a routine set of questions that tie the questions on that form to the questions here. And actually, that officer, I believe, specifically testifies that there are instructions on a form. And then, so when he says, were the instructions given here, that's a reference back to the instructions on the form. If there are no questions on the other issues, I'll rest my brief.
Thank you both. The next case is 24P 1394 Commonwealth versus LARA. Mr. Maddox.
Good morning, Your Honors. My name is John Maddox for the defendant, Kevin Lara. Before I start my ignition interlock argument, I want to just point out to the court that there were actually two statements by Mr. Lara in regard to a possible suspension. The one at the scene where he tells Detective McMeekin that his license was suspended, and then secondly, in the booking video segment, he makes a passing remark that I don't want to lose my license, apparently in regard to the ignition interlock violation. I failed to include that in my main brief. I did put it in my reply brief. I just want to make sure that the panel is aware of that additional statement in regard to the suspension. I don't think it changes the focus of my analysis, which is the RMV record. The Pettit case interprets Section 24S to apply ignition interlock violations to a valid license and not to licenses that have been revoked or suspended. It says on page 404, a license simply cannot be restricted or revoked at the same time. The same thing applies to a suspended license, not just a revoked license. In this case,
it seems to me that this really comes down to whether this uncorroborated statement by the defendant at the scene of the crime is sufficient to raise this Pettit defense. The Commonwealth cites Byung-Jin Kang on this point, and it seems to me to be dispositive. And I note that you don't anticipatorily cite it, and you don't address it in your reply brief. But the point of Byung-Jin Kang is, it seems to me, the lesson from that case is that where you have an uncorroborated hearsay statement, that's not enough to shift the burden of production to the Commonwealth. What do you say to that?
well, I think I think that's true, but I don't think that changes my argument as to the RMV record. The RMV record on the front of it says passenger status suspended. I think that evidence raises the Pettit issue.
No, but go ahead, sorry. No, go ahead.
Don't we know from the booking video, though, that his license was suspended because of he blew the 2-2 on the breath test?
Yes, Your Honor, but that's not part of the evidence before the jury. The jury does not know that. It is true that Detective Florio followed the procedure in 24-1F2.
But we do know that this RMV printout came 9 days after the incident.
Yes, Your Honor, but that doesn't mean that any suspension on the record necessarily occurred after the date of the ignition interlock violation.
You're making a sufficiency argument, though, right?
Yes, Your Honor.
Yeah, so we have to look at the evidence in light most favorable to the Commonwealth.
In the light most favorable to the Commonwealth, this evidence does not establish the timing of the suspension. I'm suggesting that necessarily involves guesswork. They can't just discredit the RMV document and say, we don't believe this where it says suspended.
Sorry, but
the jury didn't have to credit it at all.
That's right. What I'm suggesting is that as to timing, it's either that it's possible where it says suspended that the suspension occurred prior to the violation or it occurred after. If it occurred after, there is no Pettit problem. If it occurred before, there is a Pettit problem.
Help me with why it's speculation. I take your point and understand it, that there was some evidence from the motion to suppress that was not presented to the jury. But the jury did know that he had blown something, I can't remember what he blew, but higher than .08. And so they knew he had blown higher than .08 9 days earlier. And so you're saying that is not sufficient to take us beyond speculation to see that printout 9 days later was because of the blowing the .08, higher than .08?
Nobody told them about the procedure for following a breathalyzer test under 24(1)(f)(2). Nobody told them that. So the jury doesn't know. They could have, let me put it another way. The Commonwealth could have fixed the possible Pettit problem on page 35, volume 2, which is what you're referring to, that statement by Detective Florio telling Mr. Lara that he blew a .22. The next question should have been, what happened next? I informed him that his license was immediately suspended for failing the breath test, and I confiscated his license. That's what 24(1)(f)(2) tells you to do. Detective Florio did that. The jury was not told that.
They were not shown the booking video.
Excuse me?
Were they not shown the booking video?
They were not. The booking video in its entirety is Exhibit 1 to the suppression hearing. The booking video that came in, the segment that came in as Exhibit 5 at the trial is a 3 or 4 minute segment where Mr. Lara says that he took his wife's car because it did not have an ignition interlock violation on it, and then he says, I don't want to lose my license, apparently because he's anticipating an ignition interlock violation problem. But that does not have Detective Florio's statement on it. If they had introduced that, then there would be no problem.
Right, yeah, they could have solved the problem that way. But the question is, who has the burden of production here? Like, in fact, the defense could have addressed this. And I understand the Commonwealth, that generally the defense has the Commonwealth has the burden of proof, the defense doesn't have to prove anything. But that's not a universal rule. Sometimes the defense does have to produce evidence, as in Byung-Jin Kang. And so here, the judge says, you didn't produce this, you could have produced this. That's why I'm not giving the instruction. And so I think the question is whether the defendant had to produce, who had to produce the definitive evidence that this was suspended or not before the arrest.
I'm suggesting once a possible Pettit issue transpires.
Right, which you think is when he says at the scene where he says, my license is suspended. That's what you mean. That's when the issue was raised, right?
Well, that's initially where it was raised, I suppose. But I mean, I'm saying that it was raised when they put the R&B document into the, before the jury. That's when it was raised.
Let me ask it differently.
That raised a Pettit problem because
Mr. Maddox,
they're entitled to discredit him.
There's 4 elements to the crime here, right?
Yes, sir.
And the Commonwealth has the burden to prove those 4 elements.
Yes.
Beyond a reasonable doubt. That's what's at issue here. His license being suspended or not, or lack of suspension, is not a 5th element that the Commonwealth has to prove.
I believe it would fall under the restriction has to be to a valid license. That's Pettit. If his license is suspended,
there was evidence that his license was restricted. It came from him, and it came from the license itself.
I'm sorry.
The license have a T on it?
The license had a T on it that showed that he needed to use an interlock device.
Yes, Your Honor.
And he admitted he needed to use an interlock device.
Yes.
And he admitted that he was using his wife's car because it did not have an interlock device.
Right.
There are no elements of the crime that requires the Commonwealth to prove that his license was not suspended at the time of the restriction.
I'm suggesting that sometimes the element as to the restriction only exists to the extent that the license is valid. And here, there's evidence, the word suspended on Exhibit 4, suggesting that it's not a valid license. So the restriction isn't valid.
Only if we ignore the standard of review.
Excuse me?
Only if we ignore the standard of review. And we'd have to look at the evidence in the light least favorable to the Commonwealth to breathe any air into your argument.
I don't believe so. I mean, I'm suggesting that you can't, even giving the Commonwealth every reasonable doubt, looking at it in their favor, there's still a 50-50 chance that it's an invalid license.
That RMV document shows that the license was suspended on the day it was printed out. That's
no,
not
it does not. No, that's not what it says, and that's not what happened either. It was suspended about 2 hours after Mr. Lara was pulled over on November 20th of 22, 9 days before the printout. The printout is not the date of the suspension. The print.
No, that's what I was getting at.
24-1F2 controls the suspension under the breathalyzer test. That happened at around 11 o'clock or 11:30 on November 20th. He was pulled over and the violation was noticed.
Does the printout indicate that? Does the printout indicate, it doesn't indicate anything about the time of the suspension or the cause of the suspension, right? It just says
Correct.
suspended, right?
That's right.
Yeah.
There's nothing in this record that refers to Detective Florio's conduct in suspending the record or informing that under 24-1F2, the suspension takes place when the defendant is notified. And that's what Detective Florio did. So when he notified Mr. Lara that his license was suspended at around 11 o'clock or 11:30, whatever it was, that's when it was suspended, not 9 days later. And on the printout date, how does it know that it was 9 days earlier plus 2 hours after the violation? In either instance, you need Detective Meekin's personal knowledge as to the T, meaning that it is an ignition interlock violation. So either way, they didn't even need to put the RMV document into the evidence. They already had they had him saying, I looked at the license, I saw a T, I have personal knowledge that T means there was an ignition interlock restriction on this license. That's all they needed to do. They could have fixed it. They introduced the suspension without a timing. They could have fixed it 3 different ways through Detective Florio's testimony, playing the segment of the booking where he gave the notice to Mr. Lara, or simply by not submitting the RMV document. So I'm suggesting that they created an issue. They kind of shot themselves in the foot.
Wasn't the jury free to ignore the RMV document?
Yes, Your Honor.
So that sort of ends it, doesn't it?
I don't believe so. To me, that can't be the right answer because
That's the standard of review.
they can discredit it. They can say, yeah, I don't believe those guys at the RMV. I don't believe their records and reach their conviction. They can do that, but they can't disregard the evidence and engage in guesswork. I'm suggesting even if they discredit the RMV document, they're engaging in
They can credit and discredit anything they want, even if it doesn't make sense.
My argument remains that they're engaging in guesswork. I admit that this is not exactly like Pettit, because in Pettit, the revocation was clearly prior to the violation. This is just a possibility of it existing prior to the violation. I'm going to move on to my suppression claim. This is a 100C issue. The facts relate to a not guilty as well as a guilty. I'm not sure if I should file a motion to impound this part of the argument. I don't know. There was a SJC case that I was waiting for. It came down. They said I have access to the transcripts, but they didn't tell me what to do with an oral argument. I think I'm supposed to talk about the facts that relate to the guilty verdict. In any event, there was a suppression claim that in regard to a fleeing car, a fleeing vehicle, you need individualized suspicion to establish reasonable suspicion for the car stop. There are 3 factors that relate to individualized suspicion: the direction, timing, and description. I'm suggesting this case is somewhat like the Warren case, where it was a wrong direction. Here we have 2 parallel roads, Lowell Street and Moody Street. The cross streets are High Street and Pine Street. The accident occurred at 92 Lowell Street at the corner of High Street and Lowell. The 911 caller said that the person leaving the scene was going west. If you go west from 92 Lowell Street, you're on High Street going to Moody Street. So if he's going to Moody, as the 911 caller said, you're going on High Street, west. The Jeep that Detective McMeekin initially saw was heading north on Lowell Street. That's a different direction. So that's one factor relating to individualized
Does your argument
suspicion.
depend on the defendant or whoever's driving the Jeep taking the most efficient route to Moody Street?
Well, as the Commonwealth says, there are more than one way to get to Moody Street, but, I mean, you could ultimately...
There's, you know, and there's probably even more when you blow a .22.
Well, all roads lead to Rome and all roads lead to Moody Street, but I'm suggesting that that's one factor. North is not west.
I'm sorry, go ahead.
He didn't stop the car immediately, right? He observed the car to see some damage on it, the Jeep, the white Jeep.
Okay, he saw the damage. Detective McMeekin's testimony was that after turning around to follow one Jeep, he then saw what he believed to be the same Jeep, Mr. Lara's Jeep, taking a left onto Pine Street, and he supposedly saw damage on the front end of that Jeep, although, as was argued below, he's taking a left, and he's saying he saw...
If you credit that testimony, that's not sufficient?
Well, that's certainly one factor, that there was damage. I'm suggesting that you've got wrong direction, you've got a peculiar timing, and that the car had only gone 2 blocks in 6 to 8 minutes. You can walk 2 blocks in 6 to 8 minutes. So the car's going unusually slowly, and yet when Detective McMeekin turned around, caught up with it, he doesn't say it's going slowly. Also, the description is somewhat vague in the way that Warren was, which was also a wrong direction case, where it was a dark Jeep versus a black Jeep.
So, cutting to the chase, I went deep on this. The 911 call is where you find this, and only where you find this allegation that the guy who hits the car is going west towards Moody Street. That's the one source. In Lopes, the SJC says, police must be allowed to take account of the possibility that some descriptive facts supplied by victims or witnesses may be in error. This seems like a classic example of the wisdom of that holding, because the officer, it seems it all fits beautifully except for that one extraneous fact that the 911 caller apparently sees this person going off in, quote, the wrong direction. If you discount that fact, which Lopes says you can, it all fits beautifully. So
not entirely. I would still suggest the timing and the description are not quite exactly correct.
Okay. All right. That's it.
It's a totality of the circumstances kind of argument.
Thank you.
Thank you, Your Honors.
Ms. Langsom. Ms. Langsom. Excuse me.
Thank you, Your Honors. Good morning. May it please the Court. Jessica Langsom, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth.
Before I forget,
Yes, Your Honor.
You both spend a lot of time about reasonable suspicion to stop the Jeep as the hit-and-run Jeep,
Yes.
right? He saw the damaged headlight, and he saw the missing fender. Aren't those motor vehicle infractions?
He did see the missing headlight, and that is a motor vehicle infraction, and he could have
stopped him for those.
He could have stopped the car. Well, first he saw the Jeep as he's coming south on Lowell Street, and the map, which was not a great map, which was introduced into evidence at trial, is at page 73 of the Commonwealth Supplemental Record Appendix. But that shows, so as he's coming south on Lowell, the defendant's Jeep is heading north. The headlights are off, and then the headlights turn on, and that's when he recognizes that the headlights are around headlights of a Jeep Wrangler or a Jeep Gladiator.
And he's missing one. It's broken.
And it's missing. And then when they come on,
the fender's missing.
Yes, Your Honor. He notices that there are 2 headlights on the driver's side and 1 missing headlight on the passenger side. He makes a mental note of that, and I think his testimony was that that was 2 to 3 minutes from the time that he got the call to respond to Lowell Street. So then he continues to drive down to Lowell Street. He sees the crash. He puts 2 and 2 together because he sees that the passenger side is where the headlight is missing on the Jeep, and the driver's side is where the damage occurs to the white truck. So it would have been consistent with someone heading north, which was the direction of the black Jeep. He goes up, he gets back up to, it's Pine Street, which is, because High Street is lower than Pine Street, but he goes back up to Pine Street, makes a left. And with respect to what my brother just represented to the court, and I'm not suggesting that he misrepresented anything, but he says he sees the Jeep turn left and he follows it on Moody Street until he can position his cruiser to see that the fender, which is the giant part that covers the right front tire of the Jeep, is missing. It's at that point that he signals to pull over, to stop the car. And then when he stops the car, he sees that the fender is actually in the passenger seat next to the defendant. And that's when field sobriety tests are conducted.
And that supports an inference that he apparently stopped at some point and picked the fender up off or wherever it was and put it into the car. And that might account for not making more progress in the 6 minutes between the 911 call and the stop, right?
Yes, Your Honor. And as Your Honor just pointed out, that's what Detective McMeekin testified to, that it was less than 6 minutes between the time he got the call and then when he stopped the defendant's Jeep. So,
right.
And it also could have accounted for the reason why his headlights were out.
Right. And it's 9 p.m. and in Waltham, and it's not very busy, and this is the only Jeep he saw.
This is a Sunday night, correct, Your Honor. And he also testified that as he drove down Lowell Street, he was looking down side streets to look for Jeep lights, and he did not see any.
Right. Can you help me out? Maybe you can articulate it better than I could, but your citation to Byung-Jin Kang, I was struggling to articulate what I think is an important lesson from that case in this situation. This is the guy who allegedly has the antique firearm, and they say, it's not enough that you allege that you saw it on a website, in the section of the website for antique firearms. We're not going to credit, that is not sufficient, that uncorroborated claim, to raise a challenge pre-Guardado to the lack of a license. I think that's analogous to this situation where there's no constitutional right at stake, and the defendant is therefore obligated to produce evidence of the timing of the suspension if he wants to raise that issue.
That's my reading as well, Your Honor. And Guardado specifically says to properly raise the defense of an antique firearm, a defendant bears the burden of producing evidence of the affirmative defense that the firearm was manufactured before 1900, because the defendant was trying to argue as an affirmative defense that he purposely bought this firearm because it was an antique, so it's not a 10A violation. And the court says, and this was a 2017 case, authored by Justice Seifer, and the court says if there's any view of the evidence that provides support for affirmative defense, a defendant is entitled to a jury instruction. But, quote, a defendant is not entitled to a charge on a hypothesis which is not supported by the evidence. And there, exactly as Your Honor just articulated, the defendant indicated his testimony was that it was which website he purchased it on and what section of the website he purchased it on. And the court says the defendant offered no other evidence, and that, again, as Your Honor articulated, quote, bare uncorroborated hearsay, unaccompanied by any indicia of reliability, will not suffice to adequately raise the defense and will not entitle the defendant to a jury instruction. And I'd suggest to the court, as I did in my brief, that that's the situation as presented here. That it's the defendant's statement to the officer that he thought his license was suspended. There was no other evidence of that. And the only, I'd suggest the court, fair reading of Trial Exhibit 4, which is a registry of motor vehicles printout, shows the T restriction in 2 places. It does indicate under passenger status suspended, but the print date, as again, Justice Meade, you had indicated, is November 29th, which was 9 days after the crime. And the jury also in Exhibit 9, which was the breath test report form, indicating that he blew a .22 on November 20th. So I would...
It doesn't indicate on there when it was suspended.
That's correct, Your Honor. It does not indicate when it was suspended, but the jury clearly discounted the defendant's statement to Detective McMeekin, and in reconciling the evidence that was before them, ultimately determined that the defense license, well, actually didn't have to ultimately determine the defense license was not suspended because they were not so instructed, because the defendant wasn't entitled to a jury instruction on that. But ultimately determined that his license was restricted to operating only vehicles with the ignition interlock device, and that he was operating and he did not have the device, and that is, as the court's already reviewed, supported by the defendant's statements to Officer Barsom at the scene, who was backing up Detective McMeekin at the time of the field sobriety stop, and that is at, my apologies to the court, that is at the May 23rd transcript at pages 9 to 10, where he admitted to Officer Barsom that he drove his wife's car because it didn't have the device, and then the defendant's statements at booking that And it was not an unsympathetic story, but he had recently lost a friend. He was very saddened by this, but he was going out drinking that night, and that's why he took his wife's car, because he had the device on his car. He was required to have the device, and he took his wife's car because it did not have the device.
On the suspension too, the judge told counsel, defense counsel, that if you find out the license was suspended at the time, you should bring this back before me.
Exactly.
And
Justice
that
Quealy,
didn't occur.
that did not, to my knowledge, no motion for new trial has been filed. And Justice Quealy was sensitive to this and said, look, if you find out that his license actually was suspended, I want to do justice in this case. Please file a motion for new trial and bring it back before me. To my knowledge, no motion for new trial has been filed in this. If there are no other questions, I would rest on my brief and ask that the convictions be affirmed.
Thank you. Thank you both.
Thank you, Your Honor.
We're going to take a short break.
All rise, please.
All right. The next case is 24P 1200, Kirby versus MOUSIS. Mr. Bykowski.
Good morning, Your Honors. David Bykowski for the appellant Richard Kirby and Pondview Investment LLC. May it please the court, the linchpin of this case was the judge's findings of fact, which obviously affected his rulings of law on the fiduciary duty issue in the trial. And essentially, there are several documents, testimony, and the quantum of evidence is such that it's clearly erroneous to find that MOUSIS did not have an official position, i.e. was not an owner, partner on the board of directors or officer of the company.
Right, accepting that, that he was COO, that he was director, that he was vice president, and he did have a fiduciary duty as a result. What result? Why did that matter? How did he violate his fiduciary duty specifically?
He violated his fiduciary duty because of the fact that Pondview Investments clearly had an advantageous relationship with Gracie. And I'm
struggling with that because it seemed to me that the deal here was really pretty simple, that MOUSIS had the relationship with Gracie. He'd been doing business with him for a long time, so he could get the machines, and he also understood the business, moving the machines and using regulators to set those machines up where they start making money. The only value Kirby, it seems, brought to this was access to capital. And if he couldn't bring capital, then he doesn't deserve a cut of the deal. And so he's given a shot to produce equity, and he produces $184,000, I guess, but he doesn't. But more importantly, under the agreement, they have to pay this according to the schedule, and they failed. Everybody agrees, I think, that because they breached, they didn't satisfy the agreement. That agreement is null and void. And so at that point, it seems to me, Kirby had a chance to produce, and he didn't. And so MOUSIS just takes over. What's wrong with that line of reasoning?
so the deal was Pondview Investments to make. Matter of fact...
Well, it's Gracie's to make. Gracie doesn't have to make a deal with Pondview Investments.
No. There was actually a letter agreement entered into on January 14th between Pondview Investments and signed by John MOUSIS as the vice president of Pondview Investments for Pondview Investments and Gracie to make the deal. All of the money that went to Gracie, which ultimately ended up in the next deal with Pondview Vending, which, by the way, the findings of fact with respect to Pondview Vending Corporation are erroneous because the judge finds in 3 or 4 places that Pondview Vending Corporation was an ongoing entity at the same time as Pondview Investments, and so ultimately the deal was made with Pondview Vending. Pondview Vending Corporation...
It was actually incorporated 2 years later, right?
Huh?
It was incorporated in 2018, not 2016. Is that correct?
Pondview Investment was 2016.
Right, but Pondview Vending.
Right, after the deal was made in 2018.
A few days after, a week after the deal was made?
Yes. Yeah, so there was no entity at the time. All of the money that went to Gracie and that was credited toward the deal was money that had come through Pondview Investment and Pondview Investment's accounts, which the bank statements show. Now, what happened was the letter agreement with MOUSIS was entered into because MOUSIS and Kirby traveled together to South Carolina to make this deal with Gracie.
But at that point, they had already had, that's in March, right? In January.
No, in January.
Well, there's an agreement signed
Yes.
in January 2018, and that's for with Pondview Investments, PVI, as opposed to PVV.
Exactly,
Right.
yes.
And that deal signed by MOUSIS, there's no disagreement that Kirby is part of that deal, right?
Yes.
Right. And the deal includes very clearly a payment schedule that they're going to make $270,000 in payments between February 1st and March 15th, right?
Yes.
And there's no dispute that they don't make those payments, right? And as a result, Gracie is entitled to walk away from that deal, right?
Right. Then there's additional money sent through Pondview Investments accounts to
Right.
Gracie.
Right.
And they make the next deal, which is essentially the exact same terms as the deal with PVI.
Yeah, I mean,
And
yeah.
it's made by MOUSIS.
Right.
After they both go down, they sit with Gracie. This is one person who has a fiduciary duty to his partner and doesn't tell him that he's actually doing the deal with Pondview Vending Corporation, even though Pondview Vending Corporation has never been formed.
And, go ahead. Sorry, go
Can
ahead.
I, on the, there's Moose's testimony that he's an officer and a director, and there's the exhibits that show that he's those. But there's also Kirby represents to the IRS that he's the sole member and owner of PVI. So what, could the judge have credited that to,
I think the quantum of evidence is such that when you look at the admission that MOUSIS made, when you look at the corporate documents that were filed, including the statement of authorization and the board resolution, when you look at the fact that the agreement in January, on January 14th, was signed by MOUSIS as vice president of Pondview Investment. And in addition, there are documents in there at RA1, Record Appendix 1, 124 through 153, which relate to a potential loan that Pondview Investments was trying to get. And so it was a $300,000 loan from SLD Holdings to Pondview Investment, which MOUSIS signed for personally as a guarantor and also gave...
what's the significance of Kirby saying he's the sole owner?
To the IRS.
I don't know.
To the IRS, right?
Yeah.
To the IRS on that form. The testimony at trial, there was only one question about that. The testimony at trial was somehow he thought he was going to save money by listing himself as the member.
But you can't have it both ways. Where's the admission that MOUSIS makes that he is a director?
Record Appendix 3, page 35 and 36.
Can I ask you about this $70,000 payment that comes through PVI? I went as far as I could in the record, and there's testimony, correct me if I'm wrong, that money actually came from MOUSIS's partner. His name begins with a P, Palermo, and it actually came from M&M Vending, which I think was a MOUSIS entity, and so it comes in, $70,000 comes into the PVI bank account on January 22nd, and then the $70,000 in payments go out to Gracie the next day. And so it seems to me that that's all supports a very clear inference that this money paid to Gracie was not Kirby's investor money from the Soltec, but rather was MOUSIS money, which seems to me, I don't know why he used, it doesn't make any sense to me that he used PVI's bank account, but if that's all right, then it seems that that's MOUSIS's money, not Kirby's money.
Okay, so first of all, Kirby raised the $184,000. That money was raised in the spring and early summer of 2017.
Right.
At that point in time, there was $70,000 that was wired to Gracie from those funds.
Where in the record is that? Is that from the PVI bank account, the TD bank account?
Yes, in the
Okay.
bank statements.
I've got the wiring, I've got the wires right here, but it's January 23rd. But that doesn't answer, but if you look at the
Yes.
bank statement,
Yes, June 14th and May 16th are the two dates of the wires to Gracie. And that's in the statements, which I believe are at 310 to 345 or thereabouts. But you'll see that.
you're saying, I'm sorry, I've got RA 331 is a wire of $60,000 to Gracie.
No, that's, you're absolutely right, Your Honor. That's a second amount of money that was sent. There was money sent in advance of that.
Oh, there's two, okay, so there's two separate wires to Gracie?
Well, it would be three.
I mean, three.
More.
All right,
Two
all right.
separate time periods.
Okay,
Two separate time periods.
I understand. I'll
And the
take a look
money
at that.
and the money that came back at that point was actually money that had been lent by PVI to MOUSIS and Palermo for their machines in Nebraska. And and so the question is whether they had purchased additional machines with that money from Pondview.
Can I ask you about the condition precedent,
I'm
though?
sorry. The condition,
Yeah, you said the judge erred in finding
Yes.
that
So-
he had to raise between $1 million and $1.5 million. It doesn't matter, he only raised 184.
he only raised 184.
So
Yep.
you say that that is not valid because it wasn't in writing? Is that, do I understand that correctly?
Well, the judge found made several findings with respect to that. One was that it was $1 million, one that it was $1.5 million. MOUSIS's own testimony says, no, the $1.5 million didn't have anything to do with that. That had to do with the deal in Nebraska. He testified to that.
But he did say $1 million was the number.
Yeah.
The million
it's
was
at least
the
$1
number.
million.
The only evidence of the million, and the judge found that there was an agreement between them on the million, which is nowhere in the transcript. There's no evidence of any agreement. The only mention of the $1 million is an unsigned memorandum of understanding, which lists three people on it. It lists MOUSIS, it lists his partner Palermo, and it lists Pondview Investments, but by Paul Chapman.
Okay, putting aside the writing, MOUSIS testifies that there's a condition precedent, right? He said Kirby had to come up with $1 million bucks or he doesn't get to participate in the Pennsylvania market.
He doesn't really,
Does he testify to that?
He doesn't really say that. He talks about it. Well, if he could have gotten $1 million, I would have let him into the Pennsylvania market.
Can't the judge credit that?
Huh?
Can't the judge credit that?
Well, that MOUSIS would have let him into the market for $1 million, that's not the same as having an
No, just the opposite, that he wasn't going to let him in the market because he didn't come up with the $1 million.
Well, they got into PVI without, there's no evidence that those discussions happened before they were partners in PVI. There's no evidence that there was any type of a deal that Kirby ever agreed to, and his name's not even on the unsigned memorandum of understanding. And if that were the case, why would MOUSIS in January of 2018 sign the agreement between Pondview Investment and Gracie as the vice president? The red herring here is that supposedly that agreement was going to allow him to participate in Pondview vending, which hadn't been formed. And by the way, if you really look at it, MOUSIS made himself on that agreement. He got 35% directly, and then if Pondview Investment had gotten in, they were entitled to 30% of 50% of which MOUSIS would have got. It's unrealistic. That's why it was never signed, and Kirby didn't know anything about it.
We're going to run out of time soon, so I assume we agree with you that the judge was clearly in clear error about the fiduciary duty, which you argue is contingent. It was a contingency he used to explain away or find MOUSIS' favor on the other claims.
Yes.
And Justice Wood's excellent question at the get-go about even if there was a duty, how do we know whether it was breached? What do you want us to do? It's not clear in your brief do you want a new trial?
No, I think we should just have findings of fact that are clearly that there was a fiduciary duty.
But the judge, once he found there was no duty, he didn't do any more analysis.
Then send it back for a new trial.
Well, that's what I'm asking.
Well, I would just have you find that there was a fiduciary duty and that he was clearly erroneous on the condition precedent.
I guess to Justice Wood's question, if we decide it's clearly erroneous, how do we know whether it was breached, the duty, I mean?
Because there's totally, you have all the evidence of how the deal went down.
We don't find facts, though.
Then I guess it would have to be sent back for a new trial.
All right. Unless you guys say, thank you.
Thank you.
Ms. Alman.
Good morning, Your Honors. May it please the Court, Cassidy Allman on behalf of John MOUSIS and Pondview Vending, Inc.
So does Mr. MOUSIS have a fiduciary duty? Let's start with that.
I don't believe that he does.
Why not?
Well, I believe that it was at least reasonable for the judge to say that he doesn't. And my reason for saying that is there were a lot of documents introduced at trial by Mr. MOUSIS and his counsel that were documents that he had received by Mr. Kirby throughout their relationship. Some of the documents were alleged to have come from Mr. Kirby's investors that he had willing to send all of this money. Some of them...
Does Mr. MOUSIS sign one as vice president of PVI?
He does.
So what do you say about that?
That he didn't know, that he didn't realize that he was signing on behalf of PVI.
He testified that he was the chief operating officer and director of PVI.
But he
and
had...
the judge finds just the opposite.
So what I was getting at with those documents, he didn't testify that he was the chief operating officer. There was a...
It's on volume 3, page 36. It's the first thing I checked. Okay. So what I found frustrating in your brief is Mr. Brykovsky's arguing that the judge's findings are clearly erroneous. And you say they're not clearly erroneous. I don't know if you can go that far, but you support the judge's findings by citing to his findings. Mm-hmm. That doesn't do it.
My position...
You need to point to other evidence in the record that shows there was support for his findings such that we can conclude that's not clearly erroneous. But you don't do that.
I understand. I felt that there were a lot of documents introduced and testified to, some of which were purported to be from Mr. Kirby's investors, some of which were internal documents. They were all on this similar letterhead that looks like created by clip art, and all had Mr. Kirby's information at the bottom, his home address, his personal email, but on what he created was Pondview Investments letterhead. Mr. MOUSIS's allegations are that all of these documents that he received from Mr. Kirby were completely fabricated by Mr. Kirby. The ones that were purported to come from investors didn't actually come from any investors.
It occurs on page 13. Excuse me. It occurs on page 13 when you're talking about his involvement to PVI was limited to informal assistance on financial support on Kirby's repeated representation that funding was forthcoming. But you don't cite anything in the record to support that. Then you say Kirby's after-the-fact attempt to place formal duties on MOUSIS are particularly unavailing, where the formation documents, banking authorities, and spending patterns all confirm that Kirby exercised unilateral control of PVI. No citation to the record. This is not a judicial treasure hunt.
Understood.
Rule 16A9 requires you to support to the record in support of your arguments, or it's not an argument.
Can I ask about this $60,000 or $70,000, because I didn't understand your opponent's answer at all.
Yes.
But that I'm trying to follow this money from M&M. He tells me now that there were 2 separate payments to Gracie for $70,000. I only saw one payment for $70,000, and it seemed that it came from M&M, which I think is your client's entity.
Yes,
Can you shed
so-
light on this? Help me follow the money?
So M&M is an entity with my client, Mr. MOUSIS, and Mike Palermo.
Right.
That's their company
And
together.
so why did Mike Palermo send money, if he's got to pay Gracie, he was paying Gracie, I think, help me out, for an old deal, a previous deal, I guess
Yes.
paying for machines that they hadn't yet paid for.
Yes.
And, okay, why does that have to come through PVI?
My understanding of it, and I believe it's in my client's testimony, is that there had been a breakup in the relationship between Mike Palermo and Gracie. And so
Gracie,
Mr.
okay.
So Mr. MOUSIS was worried about the money coming from M&M
Oh,
rather have it go through Pondview
have the
Investments.
transcript site for that?
I don't.
Okay, all right. But so, okay, all right, that answers my question. Thank you, thank you.
And just to touch on that $60,000 a little bit more, so I noticed in your questions to my brother, you said that $70,000 came in from M&M, $60,000 went to Gracie, and $10,000 went to Mr. Kirby personally. He asked my client for money. I understand reading this whole situation because I felt this way at the beginning when I took this case on. An outsider looks at this situation and says, you know, anyone can get screwed by somebody else that they don't know when they get into business with them. Things happen, you don't know the person, but why did it take Mr. MOUSIS so long to realize
What if they are fiduciaries? And so PVI with Kirby and MOUSIS try to do the Pennsylvania deal, and then it doesn't work out. And assuming that MOUSIS is a fiduciary to PVI, he doesn't tell Kirby that he's going to go and do the deal after he creates PVV. Why isn't that a breach?
That wouldn't be a breach because the original agreement with PVI had already been canceled by Gracie because of PVI's breach. So I don't know how you can reasonably say that Gracie would offer this opportunity to PVI again.
When was that canceled?
That was in January of,
Was that on the trip
is that what?
when they went down to?
Yes.
South Carolina.
So Kirby was there.
No, sorry, this is the first agreement that they entered into with Gracie where they were supposed to make the periodic payments for the 270 terminals. This is the one that Mr. MOUSIS signed as vice president.
Right.
And then that agreement was breached. And so there was no more agreement with PVI. And that's when Mr. MOUSIS entered into the new agreement with Gracie through Pondview Vending.
And he had no obligation to tell PVI he was doing that.
I don't think so.
That's a big I don't think so.
Was Kirby with him when he did that? When he made the deal
No.
for PVV?
No.
So I just want to tie this to the record. RA 169 is the second agreement. March 15th, 2018 is at least the date of the letter of agreement. And that's signed by MOUSIS for Pondview Vending. That's so the question specifically is, and the first agreement, which is with Pondview Investment, was on January 24th, almost 2 months earlier, RA 159. Are you saying that Kirby went with MOUSIS for the first trip to South Carolina in January, but did not go with him on the second trip in March?
Yes.
Okay, so he didn't travel down there to sign the second deal.
Correct.
Okay, all right.
And another reason why I believe this would not be a breach of his fiduciary duty, assuming he owed one, I'm still of of the position that
Yeah, I
there was a
understand.
condition that was never met. Anyway, assuming that he did owe a duty, I think this would also not be a breach of that duty because PVI did not have the ability to enter into this agreement themselves. They didn't have the capital, which was clear from their breach of the first agreement. And like I said, Mr. Kirby had already ruined his relationship with Gracie.
I thought you were going to tell me that even if they were fiduciaries, he didn't meet the condition precedent to consummate the second deal. He didn't raise the money.
Well,
Is
that's
that not-
kind of what I'm saying, but I think that the condition precedent was to him getting, having any role at all in PVV, which is why Mr. MOUSIS would owe him a fiduciary duty. I don't think that Richard Kirby has any role in PVV at all because he did not meet that condition precedent.
Right.
So therefore,
No, that's, I mean, maybe we're saying the same thing. That
yeah,
if he-
it's the same argument, but yeah.
So, with respect to, you say you're still of the position that MOUSIS was not a fiduciary.
Yes.
But doesn't MOUSIS testify, and in addition to being a managing member, you are also the chief operating officer and director of Palmview Investments? Answer, yes. And you were the only signatory on the bank account of the corporation. And he says there was no bank account at the time. How do you get around that?
So the reason I was bringing up all of those documents that were introduced to show that Mr. Kirby, or that MOUSIS alleged that Mr. Kirby makes up all these documents is because he's also alleged that he made up the document that says that Mr. MOUSIS is the COO of the company. So I think when Mr. MOUSIS was on the stand at trial, he sees this document saying that he's COO. How does he?
These are sophisticated businessmen, right?
Well,
Arguably.
arguably. I think that is not the case, as is clear by these facts, but
But so the judge doesn't put the nuance, this document-driven nuance that you're putting on his testimony.
Right.
He just says he's not.
Yes,
the
but
CEO, and that is directly contradicted by his testimony.
I think that the judge has the right to assess the credibility of the witnesses after hearing all of the evidence. I know that there were documents introduced at trial, but a lot of this.
But there has to be evidence that supports his conclusion.
Right.
And that's
that
going
was
back to my criticism
and
of
that was testimony.
which doesn't work if we talk at the same time.
Sorry.
This goes back to my criticism. You didn't point to us in the record. You didn't tell me about the documents in your brief, and I still don't think I even understand that anyways. But you don't give us the ammunition to say that it's not clearly erroneous. So we're stuck.
Well, my argument is that he heard all of the judge heard all of the testimony at trial, heard Mr. Kirby's version of events, and heard Mr. Mousis's version of events, which are very different.
See, if the judge had said that, and he says, I understand he testified he's the CEO, but this cache of documents tells me that that's not true, and here's why. But none of that happens.
Mm-hmm.
And we don't have that on appeal either.
Okay. Well, if we put the, go ahead, Justice Wood.
Well, if you want to
No way
answer
around,
that
go
question, you're absolutely welcome to. I don't want to,
I'm
it
good.
sounds like, right. So this $60,000, I'm sorry to beat a dead horse, but it's actually the only thing that Judge Boudreau found for Kirby, I believe. And so it seems important to me, but it also seems wrong. And I think, I want to confirm, I just actually looked through all of the bank statements that are in the record, and I only find one wire to Gracie, and it's that one wire I was talking about in January. And there's $70,000 coming in the day before, and I'm told that that is from your client's money. There's never, so I think that is the only money, the only $60,000 going out to Gracie And so that's clearly not money from Kirby. So Kirby's not entitled to that. Do you agree with that?
I do agree with that.
Okay.
I don't know if there was another payment to Gracie at another time. I don't have record of that.
It's not in the
here.
record. It's not in the record? That's what you're
Not in the
saying? You're
record.
saying there's nothing else?
As far as I know.
Okay, all right. You're limited to the record, of course. But
Yes.
you're representing to us that the record indicates only one payment to Gracie on January 23rd, on RA 1326 for $60,000, right?
Yes.
Okay.
I'm going to ask you the same thing I asked Mr. Bykowski. Aside from what you want us to affirm and then reverse on your counterclaims, assuming that we don't do that, do you believe that a new trial is warranted, or can we find as a matter of law on all of these claims? That I'm concerned involve a lot of factual determinations.
Yeah, I think there are a lot of factual determinations necessary. I don't really have time to get to my whole argument about the counterclaim, but the big issue with that is the judge said that we didn't prove damages, even though he found that Kirby committed fraud.
You know, and you told us that you did prove damages, and then you didn't cite to the record again.
No.
So if there are factual determinations to be made, new trial.
Yes.
All right. Thank you.
I believe that the damages are not quantifiable for the fraud.
Okay. Thank you.
Thank
you both. So it's partially impounded. Our last case is 25P197, Joanne Popp versus Robert Popp. This is partially impounded. Ms. Popp.
Good afternoon, Your Honors. My name's Joanne Popp, and I'm representing myself as the appellant in this case, in this appeal. May it please the court. At the pretrial hearing for this case, the trial judge issued an order, a trial order, and the only issue enumerated to be tried was deviation from the durational limits. A modification of alimony was not listed on that pretrial order. The judge was clear. There was no issue of ability to pay the existing alimony amount, and he asked if the 36.75% of alimony, which include all employment and independent employment income, if that was still in place, which it was.
So let me stop you for a second. It seems that what you're saying here is that, well, first of all, the ARA durational limits were going to kick in August 1st of that year, and that would have meant zero. So the amount absolutely would have changed. It would have gone from whatever 8,000 plus to zero a month. You filed a motion for modification asking that that payments be continued in the interest of justice beyond the durational limits. So it sounds, because you're seeking a deviation in the interest of justice, your argument is we can affect duration, but we can't affect amount. In other words, Judge, you have two choices, zero or $8,700 a month. That's your argument?
That is not my argument, Your Honor. My argument is that under Section 53E, a trial judge can deviate from the durational limits, and also under Section 49E, the judge can modify alimony amount. Here I'm suggesting this should have been considered as a two-part test, and the reason is If a judge has authority under Section 53E, the deviation from durational limits part of the statute, if he has authority to modify amount just by virtue of a recipient filing for deviation without any material change in circumstance in the payer's financial assets and income, under the Dolan case, it's the totality of the assets and income. If there's no change in financial circumstance and there's still ability to pay, and the payer has not filed a complaint to modify amount, then if this judge modifies amount simply by virtue of a deviation from the durational limits on his desk, then this is going to set the wrong standard for numerous cases. For instance,
Wait, no, so, go ahead.
When determining whether or not the durational limit should be extended, are they looking simply to ability to pay, or are they looking to need?
I don't want to say neither, Your Honor, but I want to say when determining whether to deviate from the durational limits, the SJC is clear that you look under the case George v. George, and it's whether it's in the best interest, whether it's in the best interest, and you look at that temporally in the here and now, at the time of the hearing. And this is regarding duration.
My question more specifically is, does your need factor into the determination?
Need factors in only in a determination of whether the recipient has the ability to self-support. And that's a determination for deviation of duration, which is length of time. As we know, amount limits and deviations from amount do not apply retroactively because this divorce came prior to the enactment of the act.
But doesn't Voris, or I think it's Voris, tell us that with respect to, and we're talking about 20853E,
Yes.
right? Marital lifestyle is not a factor to be considered.
What Voris tells us is that marital
And
lifestyle...
20853E also doesn't claim
Exactly.
marital lifestyle is a factor.
To be sure, marital lifestyle is not a factor when considering whether to deviate in length of time of alimony. However, when modifying alimony amount, marital lifestyle is a factor to be considered.
Do you have a case that applies that after the ARA durational limit has run?
We filed under the SJC prior to the durational limits terminating. It was only because of the COVID delays that the trial came after my alimony had ended.
You have a case.
The cases I have, such as Voris, never got to the issue of setting alimony amount because in Voris, for example, the wife was able to self-support. So therefore, she was not eligible for the deviation in duration.
I'm struggling to understand why the court would would require that for duration we focus on the here and now and explicitly do not focus on the marital lifestyle, but then with regard to amount, we go back and do consider the marital lifestyle. That seems blatantly contradictory.
I understand, Your Honor, but another contradictory issue is if you look at the deviation section, it is clear that a trial judge may deviate in a modification or during the initial setting of alimony at the time of divorce. And there was a recent case that I read, Smith v. Smith, in 2025, where the wife did seek to deviate at the time of the divorce proceeding. And the court found that is procedurally proper for a judge to consider whether to deviate in setting the initial alimony order under Section 53E. In this case, the wife did not get her deviation from durational limits because in the here and now, there was no way to know whether, when her alimony ended, whether she would still be in the same position where she needed the extension. But the issue here is, if this court affirms the judgment and allows this new self-support standard to be applied to deviation cases, then how do you reconcile that with someone seeking a deviation at the time of the divorce? If that deviation is granted, which standard of need is applied? Is it an amount necessary to live a modest lifestyle, or is it the young decision of an amount required to maintain the lifestyle at the time of the separation leading to the divorce? And in a recent case, they extended it, you extended it to the date of the divorce, the amount needed at the date of the divorce. And that was, that case was D. Filippi v. Sewin, 106 Mass App 158 in 2025, and it states, where the supporting spouse has the ability to pay, the recipient spouse for need is generally the amount needed to allow the spouse to maintain the lifestyle he or she enjoyed prior to the termination of the
Right,
marriage.
that, I was on that panel.
Oh,
I
yes.
didn't write it, but there was no question of durational limit at that point. So there's an obvious distinction. If you're inside the durational limit, then we look at the marital lifestyle to establish the need. Once you're past the durational limit, I believe that the case law indicates that we no longer look at the marital lifestyle. That's Voorhees and George, and also the statute. And I asked you, and I'll ask again, do you have a case that applies your concept of marital lifestyle in determining the amount or the need where you've already run past the durational limit, unlike Di Filippi?
This is why I'm here today appealing this, because I believe...
Right, and so we don't have the authority to make up stuff if it's contrary to what the SJC has already held. If the SJC has already held in George that you consider the here and now in determining need after the durational limit, we don't have the authority to change that.
The SJC determined in the here and now that is the standard to apply in determining whether there is a need to deviate in duration, but not amount. The statute and the act is clear that amount and amount limits does not apply retroactively. We have to look back to the laws of modification of alimony, where there's no change in material change in the payer's ability to pay. Then when extended duration, alimony amounts set in the 2015 judgment should not have been modified. Also, we have to look back at the cases existing at the time of divorce that state the judge should take heed of the party's intent to create a separation agreement and alimony terms.
Do you think it's, so do you think, the whole point of the ARA, durational limits, is that payers shouldn't be paying forever. There has to be an end.
Exactly.
With a big safety trap of the safety net of interests of justice. And so, but you seem to be arguing that we have to tie the hands of probate judges once we've gone past the durational limits. And it seems to be completely contrary to the whole point of the durational limits in the ARA, that we basically have to continue to consider the need at the time of marital lifestyle, the need based on marital lifestyle at the time of the divorce. You're saying we don't have any, probate judges don't have any discretion to apply the here and now need. based test.
I'm saying that the judges do have discretion if they set aside the deviation of duration as part one, make a finding, is there reason in the interest of justice to deviate, which this trial judge did. Then move on to the second question, what amount do we set? Do we ignore?
Isn't that exactly what the judge did?
When he said what amount do we set, what I'm suggesting is, does he then ignore the intent of the parties?
Oh, that's a different argument. What the intent of the parties, where's the intent of the parties to pay forever?
Well, actually, if you look at our divorce agreement, it did not end at retirement. It was not.
Right, but the SJC is already, your case has already been to the SJC. The SJC already affirmed the 2015 modification and established durational limits. So I think in the law of your own case establishes that the separation agreement is not, this is not contrary to the separation agreement.
For duration, yes, I agree with this, that duration will come to an end when, and the trial judge has broad discretion in deciding that. But what I'm saying is when modifying alimony amount, for example, the Act does not touch surviving provisions. We have a surviving provision that any reduction in my expenses or my need is not grounds to modify alimony amount. What I'm saying is because of this, we agreed, even if there's a court-ordered reduction under the George case, any reduction in my alimony, in my need or my expenses. And what the judge did was he basically discounted most of my financial statement expenses because I didn't have any money to pay them at the time. And by discounting those and not giving due credit to our surviving agreement that says you can't discount all my expenses and then use that as a basis to modify alimony amount because we have a surviving provision that says otherwise. And that's, when I say look at the intent of the parties, that was one of our intents when we created the separation agreement. That the only way to modify alimony amount would be if there was a change in Robert's financial circumstances, which there was not.
Okay. All right.
Okay, thank you, Your
Thank you.
Honors.
Mr. Reedy.
Thank you, Your Honor. Good, I'm going to guess afternoon.
5 more minutes.
I'm sorry, 5 more minutes? Well, then, good morning. May it please the Court, James Reedy for the appellee, Robert Popp. As this Court, I think, has elucidated during appellant's argument, when durational limits are exceeded, the Court raises a different question in setting alimony than it does at the time of the original judgment.
Let's assume that's true. What do you say to the surviving provision?
So I'd suggest that the surviving provision, to the extent that Justice Wood asked about the amount going to zero in August of 2020 as a result of the prior SJC case and the imposition of durational limits on this matter, that surviving provision certainly didn't affect that decision.
POPP v. POPP 1.
POPP v. POPP 1, correct. Yeah. That the surviving provision certainly didn't affect the application of durational limits, and certainly alimony's going to zero or would have been in August 2020. I'd also suggest that that provision relates to marital lifestyle, which is the original question when it comes to the judgment, as what is an amount that's appropriate to be considered to maintain Ms. Popp's marital lifestyle? This court is, or the probate court was addressing a different question and saying—
What force does it have?
I don't think it has any force whatsoever. Once durational limits were imposed, I would suggest that that provision was effectively terminated except for any request for modification by Mr. Popp prior to August of 2020 when the durational limits were imposed as a result of POPP v. POPP 1.
Sorry, I apologize. I feel like this might be completely missing the boat. But Mr. Popp did move for a modification because of a dramatic reduction in income. I think that was the 2015 modification trial. Is that right?
That's correct. I believe the request was 2014 and the trial was 2015.
Right. Okay.
The judgment then.
So, and that just, your statement made me, if the separation agreement restricted where he could seek a modification, that is in fact exactly what happened in 2015, was there was a modification because of his reduced income, right?
Correct, but I think the provision that Ms. Popp is referring to is the offset of her expenses rather than the income. And I'm not familiar enough with the 2015 record to stress what happened. It's not part of this record here. But I would suggest that's Mr. Popp's request is relatively immaterial because that provision of $100,000 would have applied in 2015 because it's expenses only, not relative to Mr. Popp's ability to pay.
Gotcha. Thank you. Thank you.
I think if, any review of the record of this court below can only reveal that the court's consideration of this matter was careful. It was well-grounded in the record. It was detailed. I think there are 214 factual findings that the court carefully weighed Ms. Popp's expenses based on the record before it, provided an amount to meet those expenses. I believe it's actually an amount that's, I think, $500 or $600 per month over the expenses. I think the expenses the court determined were $6,100 a month, and the court provided $6,700 a month as alimony. And furthermore, the court's final determination that the alimony should be terminated on the date of retirement was not an abuse of discretion. It carefully weighed all the factors to be considered, and that there is nothing to indicate that there's anything plainly wrong or an abuse of discretion in this court's decision. And unless this court has any further questions, I'd rest on the brief.
Seeing none, thank you. Thank you both. We'll take it under advisement. That'll draw to a close today's session. I'd like to thank our court officers, our clerk's office, our law clerks, my panel, of course, and our excellent timekeeper. And with that, we'll stand in recess.
All rise.